Hi, my name is Tobias Leiker. I'm a bankruptcy attorney, and I want to talk real quick about reaffirmation agreements. And I apologize for my language. I know sometimes it's difficult to understand. If something is not clear, please email me, and I will answer any questions I get, or leave a comment after that video. Uh, please, please, only nice comments. Often clients are asking, should I sign a reaffirmation agreement? And it depends on the situation. If you think you can afford the monthly payment on your house or for your car, then the positive effect by signing the reaffirmation agreement is that the creditor will report to the credit bureaus that you make the ongoing monthly payments on time. So that will reestablish and increase your credit score. So that's something good, and many clients want this. The other question is, what happens at some point you lose your job, or you see that you can't afford your mortgage payment or your car payment? Then you would wish you wouldn't have signed the reaffirmation agreement. So if it's not for sure that you can make the payments in the future, you might not want to sign the reaffirmation agreement. We have the cases in which the client did not sign the reaffirmation agreement for their house. Then they lost their job a year later, couldn't make the payments, and then they were able to walk away from the house without being liable. So the mortgage company was not able to harass them with the deficiency after the foreclosure happened, because they never signed the reaffirmation agreement. On the other hand, if you don't sign it, they don't report to the credit bureaus, and you don't get that you don't have the positive effect for your credit score. So the best thing is to sit down with your attorney, talk about it, and your bankruptcy attorney will be able to perhaps suggest an option that is best in your situation. I think almost all attorneys are charging for handling the reaffirmation agreement. That money is well invested. You don't need to hire an attorney. You can do it yourself, but there are many problems by doing it. If you're not represented by an attorney, then at least here in St. Louis, Missouri, then there will be a court hearing, and you would have to show up at the court hearing, and the judge is actually looking at the reaffirmation agreement and is looking if you can afford the reaffirmation agreement. And if the judge thinks it's not in your best interest, he will not approve the reaffirmation agreement. Or if you sign the reaffirmation agreement, you send it back to the creditor. Sometimes the creditor does not have a local counsel here and will not file the reaffirmation agreement with the court. So you think you have a reaffirmation agreement in place, and then you see they don't report to the credit bureaus, and then you call them and they say, well, we never filed the reaffirmation agreement. So there are many problems with not letting your attorney handle the reaffirmation agreement. Here in St. Louis, Missouri, we have a reasonable fee for handling the reaffirmation agreement. I know some other attorneys are charging more. It's well invested. So my advice is talking to your attorney about the reaffirmation agreement and let them handle this, because otherwise often it's a big mess if the attorney is not involved. If you have questions about the bankruptcy process or reaffirmation agreements here in the St. Louis metropolitan area, call us at 636-916-5400 or go to our website and send us an email. We have offices in St. Louis, in St. Charles, and on the Illinois side in Granite City. Okay, thanks. I hope everything was clear so far. Thanks.